Melvin L. Raymond, attorney and counselor at law. Welcome to Raymond Law Live. This is the inaugural webcast. I want to give a shout out to Better Family Life and the Sims and Bailey Law Firm. Better Family Life is holding its 32nd annual Unity Ball this coming Saturday, November the 17th at 6 p.m. at the Airport Renaissance Hotel. For more tickets and information, call area code 314-367-3440. Sims Better Family Life is having the ball to celebrate its efforts to breathe new life to the North City and Page corridor. So they're having their Unity Ball again on this coming Saturday at 6 p.m. at the Airport Renaissance. Sims and Bailey is a law firm here in the Central West End offering quality legal services and expert representation. For more information, call area code 314-534-0800. Before we start today's topic, I want to commend and thank everyone who participated in the midterm election last week, Tuesday of last week, for exercising your power at the polls by voting and helping others to vote. Voting is very important in this democracy, and I want to thank everyone who did that and helped others to do that. Good for you. This is the inaugural broadcast which I dedicate to Wazella Raymond, my late mother, and Charles Roosevelt Raymond, my late father. Now let's go on to today's topic, which is power of attorney. Most of you, or many of you folks, probably know a little bit about power of attorneys. Power of attorneys is something that many of you may find the need for legal representation. So let's get into our topic for today. What is a power of attorney? A power of attorney is a document by which a person called the principal, that's P-R-I-N-C-P-A-L, gives authority to another person who's called an agent to act for or on behalf of the principal. The principal, or the agent rather, is referred to as attorney in fact. That is the technical term in the statute for a person who is serving or been appointed under a power of attorney. And that's true in Missouri and most other states. The agent is called the attorney in fact. That's the technical term. Now, when does what are the requirements for a valid legal power of attorney? One is that it has to be in writing. So it's a document or instrument that must be written. It must be dated, and it must be signed and acknowledged. Now, acknowledgement means that it has to be in proper form and executed before a notary public. That's all those things to make it valid. Who can serve, or who is qualified to serve as or be appointed as an attorney in fact or an agent? It has to be a person who is an adult, that is 18 years of age, who is willing and able to serve. Now, one thing about power of attorneys and who you appoint is you should appoint someone who is able and willing and available to do what you want them to do or what you authorize them to do in your power of attorney. That point is very important because they're going to be acting for you on your behalf, and you want someone you can trust and who is capable, available, and willing to do what you authorize them to do in the power of attorney. Also, the relationship between a principal, the person that grants a power of attorney or appoints, and the agent or attorney in fact is called fiduciary in the law. Fiduciary means that it's a confidential relationship, and the attorney in fact must act in the interest of the principal. That means no self-dealing. You're acting in the interest of the principal who appoints you under power of attorney. No self-dealing. You can't be transferring the property of the principal to yourself. You can't gift yourself. It's a confidential relationship of trust, and that's very important. So if you're contemplating accepting a power of attorney appointment, then you need to act only in the interest of the principal who appointed you. Now, when does a power of attorney take effect? Well, it could take effect when you sign it or execute it after you get it duly acknowledged, or the instrument can provide that it becomes in effect upon your disability or incapacitation. When is it advisable to execute a power of attorney? It should be done in the event that you become disabled or incapacitated. So it's a good way to plan ahead. Obviously, if you're already incapacitated or disabled, you may not be able to sign a power of attorney or have the capacity, the legal capacity, being of sound mind, to execute the power of attorney. So think about it. If you think it's good to have that available in case that you need it, and if you don't need it, then it's better, as they say, to have it and to need it and not have it than to not have it and need it. So keep that in mind. A power of attorney is durable. It's important that it be designated as durable. Durable meaning in the law, there has a special meaning in the law. Durable power of attorney means that the power of attorney does not terminate upon your incapacity or disability. That's what makes it durable. It doesn't terminate. Also, there are two kinds of power of attorneys. One is a power of attorney that deals with property matters, financial matters, personal business matters. So that's one kind. They can provide for general powers. The second type of power of attorney is a power of attorney for healthcare. And as the title indicates, a healthcare power of attorney only deals with healthcare matters. It doesn't deal with financial or other personal business matters. If you want to join the discussion, you can post your questions or comments. You can do that now. We are going to complete the presentation, but go ahead, if you want to join the discussion, go ahead and join us by posting your question or your comment. With respect to healthcare power of attorneys, one thing that's very important is that the purpose of a healthcare power of attorney is to make decisions for the principal for medical treatment or any kind of health care. You can make a decision regarding or withhold or prohibit any kind of medical care, any kind of medical treatment, and so on, as you designate in a healthcare power of attorney. If you only in the instances where you may want or not want the withdrawal or as to artificial hydration or feeding, then you have to specifically indicate that in the healthcare power of attorney. If you don't specifically indicate that you do not want or you want withdrawn artificial hydration or nutrition that's tube feeding, then you need to specify that in the instrument itself. Now, let me, I got some questions here. Can you reverse the power of attorney? You can do that. You have to do that by indicating your intention to terminate the power of attorney. Now, how do you indicate your intent to revoke or terminate a power of attorney? The best way to do that is to do another document called a revocation of the power of attorney. So that's how you accomplish that. But the law does provide that you can communicate your intention to terminate the power of attorney on any manner, that so long as it's clear that that's what you want to do. And of course, you need to notify whoever you've appointed to serve as your attorney in fact. But that's how you can terminate a power of attorney. There are other ways too that you can terminate either a general power of attorney for financial and property matters or healthcare power of attorney. If you get divorced, unless you provide otherwise, the power of attorney, the power of attorney would terminate by operation of law. And there are some other instances under the power of attorney statute that provides for ways that it may be terminated legally. Another way, for instance, is if you get a court-appointed guardian. Should that happen to you, then the guardian has the legal authority to terminate the power of attorney. So just like you appoint someone as attorney in fact, you can terminate them and terminate the power of attorney by revoking the power of attorney. So we still can take your questions about power of attorneys. Remember, there are two kinds of power of attorneys. The one that deals with financial matters, and as far as what can be done with power of attorney, the authority that you grant to the attorney in fact can be as broad as you want. It could cover all kinds of things, everything from making deposits in the bank to withdrawing money to writing checks and so forth. It could handle real estate matters. You could have an authority to, you can grant an authority to an attorney in fact to handle real estate matters. It could be as broad or as limited as you may want. It can cover things that you may need to have done that you cannot do yourself. If you just want somebody to handle one real estate transaction, you can have a limited power of attorney, and you can just, for that purpose only, to handle a real estate closing, for instance, or handle a loan transaction. If you want a special limited power of attorney, then you can do that. I've got a question here. Someone is asking, does the power of attorney expire? The answer is yes, upon death. It's a principal-agent relationship, so when you, upon death, it would automatically terminate by operation of law. Otherwise, the power of attorney will remain in effect unless you yourself terminate it by a revocation of the power of attorney. And the revocation, of course, would have to be a separate document and would need to be in writing. Of course, you need to deliver the power of attorney to your attorney in fact. I have a question here. Does the power of attorney need to get renewed yearly? No, it stays in effect as long as you want until you terminate it yourself by revocation or by your death or by operation of law, as if, for instance, you get a court-appointed guardian and so forth. But no, it stays in effect as long as you want until you decide to terminate it. So that's what happens. There's no need to renew it yearly or at any time. So we're still getting questions, so keep the questions coming. You need to have a question here. Do you need to file the power of attorney at your county or city office? The answer on that is generally not. Generally not. You don't need to file it with the recorder of deeds in the city or the county where you live. one exception may be if the power of attorney affects real estate. Let's say in your power of attorney, you're authorizing your agent or attorney in fact to sell property or mortgage property and so on. It may be helpful to record it if it deals with real estate matters. But I would not, so generally not, no, don't record it, but it may be useful if it authorizes your attorney in fact to deal with real estate matters. And I would, in that instance, I would only record it if there's going to be some real estate transaction and that's asked for by one of the other parties, either the buyer or the seller. So generally not, except maybe when you're authorizing real estate transactions. The questions are still coming here. I have a question. Is it expensive to file? Well, power of attorneys aren't expensive. You need to make sure that it's a legally valid document. You do need to have legal representation to prepare it so that it's in the proper form, it's properly dated, it's properly acknowledged. Because if you don't do that, then it may not be legally valid. And one consideration is that third parties who may be dealing with your attorney in fact, third parties such as banks, such as insurance companies, such as the Social Security office, they're going to want to see the instrument, and you need to make sure it's in proper form. So I would recommend that you get legal representation if you're going to make sure that your power of attorney is valid and that others, third parties, banks, Social Security, and so on, IRS, whoever the third parties may be with whom your attorney in fact may deal with, they need to accept the document, and you want to make sure that they do that. So I recommend that you get legal representation for that. Questions are good, so keep the questions coming. And again, I mentioned that many people often wonder, I don't need a power of attorney, I'm young and I'm strong, so I don't really need one. Well, young people may need power of attorneys, or younger people. It's not just for the elderly. Let's say, for instance, you get involved in a car accident tomorrow or the next day, and you're not able to do much for yourself. You can't go to the bank, you can't deposit checks, you can't write checks. In that case, a little bit of planning would be good to have a power of attorney, or if you're ill or whatever. So it's not necessarily for the old and the aged. It's good. It's a tool actually of estate planning. That's one aspect of estate planning. So it's good to think about that. And if you don't need it, then you can still have one in case the occasion may arise where you do need it. So I would suggest that you consider that as far as a part of your good planning, as far as handling your personal affairs and so forth. It's a good thing to have on hand in case you need that. There are, of course, other aspects of estate planning, but I think that power of attorney is one, and that's what I want to address. That's the topic for today, so I wanted to let you know a little bit more about how you can use it and maybe when you can use it and so forth. So if you have any questions, again, I invite you to join our discussion here today on Raymond Law Live. The topic again is power of attorneys. So you can join us with your questions or your comments. I've gotten several questions and comments so far. So if you have any others, just join us, the discussion. I hope that you've learned a little bit more than you knew before about power of attorneys, and I think it's always good to know about things. Remember, when you fight, you should know your rights, and this is one thing you should know about that I think will be helpful to you. Oh, I want to, at this point, to give another shout out, a closing shout out to Better Family Life for their 32nd annual Unity Ball this coming Saturday at 6 p.m. at the airport Hilton Airport Renaissance. And their number you can call for tickets or information is area code 314-367-3440. And I also want to give another shout out to the Sims and Bailey Law Firm. They offer quality legal services and expert representation here in the Bi-State area. For information, you can call them at area code 314-534-0800. Now, I'm glad, and I want to thank you all who watched us live and who will watch this broadcast later. I appreciate your time and your interaction with us today. Remember, we're going to be here again, same time next Tuesday, November the 20th, same time, 6 p.m. Central. And remember, when you fight, know your rights.